And it is what cannot be refused, that the bulk and body of Presbyterians in Scotland did state a secession upon that form and model of prelatic government that was established in the year 1662, and their refusing communion with the prelatic Church of Scotland was made a handle for that violent persecution that was raised against them. But according to our author's way of stating the case in that tyranny in government, unless there is most cruel and habitual tyranny, with intolerable persecution of soul or body, there is no ground of secession from a church on the head of tyranny. Yea, further, according to our author's way of reasoning, it appears to me that there is no ground of secession from the prelatic Church of Scotland purely upon her form and model of government. At least, that church members might have entertained communion and worship with that church, especially when it is considered that, during the late times of prelacy, the ceremonies of the Church of England had no place in her worship. Again, a church may be said to be tyrannical in her government when the administration of her government is tyrannical, as, for instance, though Presbyterian church government as to its form and model is divine, yet if under the shadow of the said government a lordly and magisterial power is exercised over the heritage of God, if the flock of Christ are ruled with rigor, if the keys of government and discipline are perverted, in these cases the administration is tyrannical, and the government is not a whit better than if its form and model were prelatical. We used to say, corruptio optimipessima. This tyrannical administration of the government lays a just foundation for secession from church judicatories who are walking quite contrary to the end and design of their erection and constitution in the church, and who thereby forfeit their claim to the exercise of the keys of government and discipline in the house of God. And that this is the state of matters in the present judicatories may be made evident afterwards. I shall only add further, for clearing this head, that it is not sessions, presbyteries, synods, and general assemblies that make us truly a Presbyterian church, but the free access of church members with their grievances unto these courts, and the exercise of ministerial power and authority in them for the edification of the body of Christ, for the redress of their grievances, for the removal of offenses, whereby the flock of Christ may be hurt or stumbled, for the preserving the institution of Christ in their purity, for maintaining that liberty wherewith Christ hath made his people free, and for purging the church of such errors or erroneous persons whereby the whole body is in danger to be leavened. If power and authority is not exercised in the said judicatories for these and the like valuable ends, to the honor and glory of the head of the church, or if it is exercised by the judicatories of a church unto quite contrary ends and purposes, what remains but a prelatic government under a Presbyterian name and shadow? The fourth instance given in the essay is concerning the institution of ministers. Page 29. Quote, "Some," says he, "make the intrusion of ministers upon Christian congregations a ground of separation." Unquote. He owns that the charge of violent intrusions, quote, "is a charge from which the Church of Scotland can be least vindicated of anything laid to her charge since the Revolution, considering how many settlements have been made, when congregations were reclaiming, since the Act restoring patronages, anon 1712, unquote, page 30. What he adds concerning the stop that has been put to such violent settlements, I shall afterwards consider. But he further adds, quote, "Whatever ground there is for lamentation, there is no sufficient ground for separation from the Church of Scotland, notwithstanding of such intrusions. Whatever some particular congregations may have to say for vindicating their practice and not attending upon the ministry of such as are violently thrust upon them." Unquote. Here again our author perverts the true state of the question in regard to the present judicatories of this national church. The present judicatories of this national church must be considered as carrying on, authorizing, and supporting violent settlements, notwithstanding of manifold remonstrances against their conduct and practice, both by ministers and other church members. And consequently the question is, whether or not this, with other acts of tyranny in the administration that may be afterwards named, justly infer that the present judicatories are so tyrannical in their government that our secession from them is necessary and warrantable. Our author endeavors to impress his readers with his great zeal against violent intrusions, yet he thinks fit to make an apology for his brethren that are active in carrying on violent settlements, when he tells us, on page 32, quote, "Though I am not to vindicate them, yet sundry of our brethren who have gone lengths in appearing for candidates, having presentations, which others cannot but condemn, have declared, was it not for the strait the church is in, from the grievance of patronage, which they profess as a grievance to them as well as others, they had been as aver from countenancing such settlements as any, unquote. It is a very mean apology for them to tell the world that the grievance of patronage, that is, the civil law establishing patronages, has led them to counteract the laws of the only Lord and lawgiver of Zion. If our author had dealt faithfully with his brethren, and according to the great zeal that he professes, he ought plainly to have told them that they should rather suffer than sin. But that he may still extenuate their sin, he likewise adds, quote, they affirm the gravenanimous law of patronages, constrained our church judicatories, even in the best and purest times of Reformation, to the like measures, unquote. Our author must needs have a great deal of assurance when he reports without a just remark upon it, that his intruding brethren affirm that the judicatories of this church in her reforming times pursued the like measures with the present judicatories in the settlement of ministers. This is a most injurious reflection upon them. Can his brethren give one single instance of their pursuing the like measures with the Assembly 1737 in their act and sentence and at the settlement of the parish of Denny, besides many other particular instances that might be given? Or can our author or his brethren give any instance of aggrieved and oppressed congregations coming before our general assemblies in our reforming times with a loud cry of oppression on the account of the violent settlement of ministers among them? But how many instances have we had of this kind before our national assemblies within these 20 years by past? Yet he tells us they affirm that our church judicatories in our purest times of Reformation took like measures with the present. And, if it is not truth which they affirm, what end can our author propose to himself by reporting it in his essay without a just remark upon it, unless it is that he may extenuate their sin? Upon this head of the intrusion of ministers, the essay observes on page 29, quote, that sundry of the dissenters from the Church of England have judged the want of a free choice in the election of their own pastors is enough to vindicate them in separating from the communion of that church, unquote. But it seems he has not found a Scots Presbyterian divine that makes the intrusion of ministers a ground of separation. Since our author thinks fit to deal so much in authorities, I shall give him two testimonies upon this head from an author whom he justly commends, that is, Mr. Shields, on church communion, who, on page 18, mentions, quote, 4 general grounds of separation commonly allowed by all: heresy in doctrine, idolatry or breach of the second commandment in the matter and manner of worship, intrusion or tyranny of government, and schism or a divided government, unquote. This worthy author is pleading for communion with the ministry about the time of the Revolution, and he applies the 4 general grounds in the following manner. Speaking of the ministers at that time, he says, quote, for as none can doubt their right to administrate all ordinances, so there is none of these ordinances perverted by them, either in the matter or manner, since they are not erroneous in doctrine, nor do break the second commandment in worship, nor intruders or tyrannical, nor schismatic in discipline or government, unquote. I heartily wish that we could say as much concerning the present ministry and judicatories of this church. From the above words it is plain that intruders and tyrannical are one and the same with Mr. Shields, as also that intrusion or tyranny in government, when it prevails in a church, is a ground of separation commonly allowed by all. Likewise, the intrusion of ministers was one of the grounds upon which a secession was stated from the Prelatic Church of Scotland by the body of Presbyterians, as the same author shows at length, Hind Let Loose, page 236 and 237, to which I refer the reader. When the author of the essay in the words cited above seems to allow that particular congregations have something to say for refusing to submit to the ministry of such as are intruded upon them, I humbly judge ministers may have as much to say who refuse communion with such judicatories as obtrude ministers upon Christian congregations. There is as much reason on the one side as the other. Yea, there may be more reason for refusing communion with the judicatories, if there is any weight in what our author very well knows. Intruders have sometimes pled in their own defense that they must submit to the authority and obey the sentences of judicatories, and if the judicatories did not include ministers upon congregations, intrusions could not take place by any other means whatsoever. His next instance of a ground of separation is when ministers are scandalous in life and conversation. And here I have no difference with him. For he not only tells us what some affirm and what some think, but declares it plainly, that he is much of their opinion who think, quote, such as are evidently scandalous may be withdrawn from, albeit through the iniquity of the times. They should not be censured by a church judicatory when complained of, unquote. The last instance he gives of what is reckoned ground of separation is, quote, the imposing and least sinful term of communion upon us, unquote. Here again he delivers himself plainly, for he owns that this is ground of separation from a church. He adds, quote, some have been of opinion that this is the only ground that can justify separation from a church, unquote. And here, at the foot of the page, he cites Cloud's defense of the Reformation, but he cites no place of that book, and if he pleases to consult it, he will find other grounds of separation advanced. For instance, Cloud affirms, quote, that when corruption spreads over all the body, that is, of the ministry, in such a manner and to that degree that the safety of the faithful cannot longer subsist under the conduct of these persons, and that there is no hope among them of any amendment, then the only remedy that remains is to separate from them. And it would be so far from either violating the order of God or opposing the ministry that he had set up, that it would be on the contrary to deliver it as much as in us lay out of the hands of those who have invaded it, and to draw it out of that oppression to which they have reduced it. This separation, therefore, openly regards those persons who were unlawfully called to the ministry and who abused it against God and his church, unquote. And here, by and by, our author may observe a famous Reformed divine acknowledging the justice of separation from those who are unlawfully called to the ministry. And I leave it to himself to judge, if intruders are lawfully called to the ministry, as also whether or not the ministerial power is abused against God and his church when men are intruded upon dissenting and reclaiming congregations who are willing to have a gospel minister settled amongst them. He cites also, at the foot of his page, Bishop Burnet's history of his own time. But he might have been ashamed to have mentioned one who is known to be abundantly lax in his principles about church communion, and especially when in the place to which our author directs us, the bishop is reasoning against separation from the Church of England. Our author proceeds on page 37 to give some particular instances of sinful terms of communion. He names 7, wherein I agree with him. Only I crave leave to express his seventh in the following manner, namely, if our communion or conjunction with any particular church binds us up or restrains us from the discharge of any duty which our station, office, and character by the command of God does obligate us unto, whether the restraint that is laid upon us be explicit or more implicit. This I have illustrated already, and I hope our author cannot reasonably refuse that it makes conjunction with any particular church equally sinful with these instances that are given by himself of sinful terms of communion. I proceed now to section 3.